May it please the Court. Good morning, Chief Justice. Good morning, Your Honors. Mark Kitrick here. I want to talk about what this case is about, which you've hit on, and that is the appellants want to legalize lying via a limited warranty. We didn't hear one time in the last 20 minutes this whole case stems on fraud by non-disclosure, purposeful concealment that a non-runaway jury in Newark, Ohio found. They had 3 claims to judge. This was not a runaway jury that we sometimes see or hear about. They rejected misrepresentation. They rejected a breach of contract. They found there was fraud by non-concealment. And that is critical because that is a discerning and different tort that bore literally this limited warranty. Navistar never would have bought these trucks if they had been told the truth. They concealed it any way they could. Specifically, this was a Max 1, Max 2 situation. They had Max 1s, they knew there was a problem. To answer your question, Chief Justice, yes, of over 100 repairs, the vast majority of them were EGR valve problems that was purposely withheld by the appellants throughout numerous conversations that our clients had, coming back to them and saying, what's going on here? And it wasn't misrepresentations. We know that we try to keep misrepresentations, allow it to be disclaimed by warranties so we can have an integrated contract. This is different because this is fraud by not telling, by lying, covering up. That's what this jury found after listening to the evidence, listening to the experts, listening to the representatives of each company. Once that happened, they felt, wait a minute, what's going on here? We're not being told that these trucks have numerous problems. They purposely withheld information on the valve having numerous problems, that they didn't have the test time on the road like they claim. These trucks are supposed to run about 1 million miles. They were having problems after 100,000 miles. They were losing value. So when we go to your point, Your Honor, about the warranty, this is not, it kind of brings me back to the St. X days and our law school days where we had to take Latin. It brings me back to the just and generous interpretation of statutes and contracts. If you're going to have a general statement and you start delineating specifics like they do here in this warranty, then everything's interpreted by like kind. There's not one single reference in this warranty for non-disclosures or reliance. Remember, it's well said in the Textron case by the judge, warranties involve reliance, which is really critical because reliance is what were you told or what were you not told. It's one thing to disclaim misrepresentations. It's another to somehow know you should disclaim things you never told about to make a decision to begin with. These were material points purposely withheld, which caused them to buy the contract. So we have the beginning of this, none of the parole evidence issues here. We don't have fraud where people are trying to say there's fraud when there's a contract. We have fraud happening, which then created an express contract that was based on
the fraud was what? The statements?
The fraud was the lack of the statements, Your Honor, and that is the key. This is not, the jury actually rejected misrepresentations. They found fraud by non-disclosure, and that's a critical distinction because we don't want to lump misrepresentations and non-disclosures in one bag. They're recognized differences of claims, one to tort, one could be a potential contract breach. What's important here is we actually have it recognized by law that these are different claims. In essence, if we think about any of these things, think about how we define negligence or releases that we all see in cases, and it's akin to a release in a way. We start putting in words, we better put in all the right words. We have acts or omissions. We have releases that get into acts or omissions. We're not afraid to put in things that should be included if we're going to disclaim something. But we don't want to sanction, this court does not want to sanction corporations trying to claim through a limited warranty.
I don't understand, if we adopt your view, what is the point of a warranty? Will you disclaim warranties of merchantability and fitness for a purpose, all other representations?
That's true.
I mean,
warranty is very important.
Do you think the Court of Appeals got it right, that just because this was some kind of boilerplate, it wasn't important?
Yeah, I think the Court of Appeals did get it right, Your Honor, and I'll talk to your point. We want warranties, absolutely. We want to say, okay, here's what we're promising and what we're not promising. That's different than a non-disclosure situation. For example, in warranties that are upheld by this court and others, it's usually language that says full and fair warning. that have everything in it. This is a boilerplate disclaimer. It did not include reliance. It only included liability. It did not disclaim the failures to disclose material information, and it was just to fix trucks that break down, which they did, and the jury found that. So this was, Goodyear wanted a full and fair warning. This case did not have it. So if we're going to have warranties that are going to be upheld, Your Honor, as you say, then they better have everything in it so that non-disclosure is included. Now, that's
Counsel,
a public policy.
What gave rise to the obligation to disclose here? Because there's a million things that a seller of a vehicle like this could or could not disclose. So what gave rise to the obligation to disclose, and what was it that they should have disclosed?
That's a great question, Your Honor, and it's very specifically brought out in the trial. This company, our client, had problems with these trucks at the Mach 1. So they were worried about this valve, which supposedly takes the exhaust, sticks it back in, and so it creates a problem in the exhaust system. So they specifically said, hey, we bought some of these trucks, there was problems, Mach 1. The company, the appellant says, we got Mach 2, now that's a lot better. We've already tested it. We've got this, we've got that, we've done it. So our clients...
But wait a second, that's not non-disclosure, that's representations that you're talking
Well,
about.
then they went, to answer that point, Your Honor, then they went to the company, the appellant, and said, what are you doing about this Mach 2 problem and the valve problem? They specifically addressed it numerous times.
Okay, again, you're talking about representations. You say they went and said, what are you doing? The response is a representation, which the warranty clearly disclaims any representations.
That's, when they went and asked the questions, I'm not talking about misrepresentations. The appellant here specifically did not disclose the problems they were having. It wasn't a question of what they said or lied or exaggerated.
It seems like you're kind of trying to slice a very thin apple there. I mean, when you say they went to them and they asked and they didn't tell them something, but that to me is a representation. I mean. Well,
I disagree, Your Honor. I think if we've got, the law supports non-disclosures or representation for misrepresentation.
So if someone says to you, are there any problems, and you say, no, there's no problems, that's a representation.
No, they didn't just say there's no problems. They didn't tell them about any of the facts that they were having problems with this valve or all the facts. They literally didn't tell them anything. They concealed it. And that's where the jury found there wasn't misrepresentations, but there was non-disclosures. How many times in real life have we told people after we hear a story, said, you know, I really wish you would have told me that. That was important for me to know, and when I made a decision or making a judgment call on what happened here. So you're right, it's a fine slice, but it's definitely delineated in the law because we have separate claims that the jury looked at here. We have separate laws for non-disclosure and fraud. This is fraud by the inducement. That's separate from misrepresentations.
Why isn't this just a contract claim? You know, someone buys a truck, the truck didn't perform the way it was supposed to. That sounds to me like a contract.
Because this contract was born out of the fraud and the inducement to begin with. So we don't want to merge the contract in the fraud.
But we have the rule about fraud in the inducement when it's within the scope of the written contract. Listen, you can't have a claim. That's Textron, right?
Yeah, but this is not Textron. Textron was a plenary discussion. They were negotiated. It wasn't boilerplate as it was here.
Well, wait a second. Wasn't boilerplate. Where has that ever been a factor between two commercial parties?
Many times. I mean, here's the maker in
Many
this
times
case.
when? Between when you have two sophisticated commercial parties, when has one ever been able to say, well, we didn't, this is boilerplate, we didn't actually read it, our attorneys didn't matter?
Well, I didn't say they didn't read it. This was made by the appellant. This was their warranty they disclosed.
Right,
and they signed it. So, but it didn't include. If they're going to make it, then they better make it good. And they didn't. They didn't say all reliances. For example, let's not forget the distinction between reliances. There's no discussion in that warranty saying any and all reliances we disclaim. There's not one word of reliance in that express warranty. 4 times on damages, but not once on reliance. And that's important. Now, if they had said any reliances are disclaimed, ever made, that's a different story. We wouldn't be here potentially.
So, Mr. Kitrick, so
Yes.
the first purchase of the Max Force 1 trucks were in 2008 and 2009, correct?
Correct.
And then after 100,000 miles, the trucks began to have problems?
Correct.
So then the Max 2 trucks were released onto the market into the market, or at least for sale, in 2010.
Correct.
And 2010 and 2011 was the purchase of the MAX 2 trucks. So the question of the testing and whether the MAX 2 had been adequately tested, like basically stress tested, do you think that that is something that made a difference to your client? If they would have known that they weren't tested to the point where they could be released?
The answer is yes. In the court case, the trial jury heard, Your Honor, everybody heard that had they known this, had this been disclosed and not held back or concealed, they would not have bought these trucks. It's done. This deal wouldn't have happened. So it's one thing to say, well, fix your trucks. It's another to basically mislead by inducement and have you make the deal to begin with. And that was the key. And that's what happened here, and that's what the jury found. We can't let corporations reap the benefits of deception that lead to purchases and paying nothing, which is what they want to do when this kind of fraudulent conduct, which is found by a jury, occurs. That is the worst public policy that this state of Ohio would want. We want to have good contracts. We want to have businesses do business here and spend money. But we sure as heck don't want to sanction conduct that say, okay, if you write it, we're just going to let a limited warranty boilerplate that's not fully negotiated.
But your client could have negotiated for whatever kind of warranty they wanted, right? They'd have to buy trucks from them. They could have negotiated the warranty. They could have said, if this is the warranty, we're not buying it.
If you want to get into whether or not you can make that decision, that's an informed decision. If you've got the knowledge to make it, that's true. But if you don't have the knowledge or have been misled by concealment, how can you actually make a really informed decision at that point on a material decision-making situation? That's the problem, Your Honor, is if you don't tell somebody the truth about it and you lie about it, how can you say that that's a good informed decision when you sign something? That's the problem we have here, and the jury found that to be the case.
I mean, so you had a warranty that the warranty covered repairs. It didn't cover time for, you know, your losses for not having the vehicles. That's the, if you wanted to negotiate for that, you could have negotiated for that. You would have had to pay more, I'm sure. But you didn't negotiate that for that. So why should the court change the bargain that you made into something else?
Well, the jury, first of all, didn't find there was a breach of a misrepresentation here, a breach of warranty. The jury agrees in that sense that they didn't say that the warranty was breached. They found, wait a minute, the whole warranty occurred because of the fraud and the inducement to begin with. And we just have to remember that we can't mix the two. This court has continuously upheld special tort, separate actions compared to contract actions. The jury didn't find there was a breach of contract here. They did try to fix these trucks numerous times that were back more than they should have been, but they found, wait a minute, they were lied to, not by misrepresentations, Your Honor, but by omissions, fraud by nondisclosure, which was enough to cause our client to buy these trucks when they wouldn't have bought it. To answer your question, Your Honor, they wouldn't have bought these trucks and wouldn't have made this deal to begin with.
So, counsel, what you're saying, the warranty is irrelevant at this point. It doesn't matter, I mean, the way this warranty is written, it's irrelevant to the fraud that preceded the execution of the contract with this warranty in it. So focusing on the warranty is really misfocusing.
Actually, that's what I thought of when I was coming over here this morning, Your Honor, that we keep talking about warranties, but really we can't forget this all started with the fraud, and that's where this is. I'm certainly open to any other questions the court has. In conclusion, I would say the appellants want to reap the benefits of deception here that led to the purchase of these trucks and paying nothing when there's just a solo damage award, which was lost profits and diminution of value from our jury. It's an unreasonable, unfair, frankly unconscionable result. We want to deter fraud. We want to discourage it. We want to uphold proper contracts that have been engaged in. This court has the power to stop such conduct, and we ask that you enforce the lower court's ruling and uphold the jury's finding from 3 years ago. Thank you very much, Your Honors.